Right. Thanks, Mr. Kramer. Good morning. Oh, gosh, no. All three of us were trial judges, and we know when we picked a jury and we got that tepid of a response, it was going to take a while to get through voir dire. So good morning.
Morning.
All right, much better. Okay. Good morning. Actually, the PJ is still the Honorable Christopher Murray, the Chief Judge Pro Tem of our Distinguished Court of Appeals and Court of Claims, I think. But he's not able to be here with us today. If you come back tomorrow, he probably will be. So if anybody wants a pass from the principal, we'll let you come back tomorrow. No, we prefer to do it today. But at any rate, Judge Murray is with us electronically. And Judge Rick and I have the privilege of being here with you today. Thank you for, in all the captions, Judge Murray is still going to be the presiding judge, so we're not going to be changing that. Thank you for being here. We appreciate everyone's briefs. We've reviewed all of them. We've discussed many of the cases that we're going to hear today and tomorrow already among ourselves, both directly and by email. There are a number of files that have either sexual assault allegations, which have resulted in convictions, where we have complaining witnesses whose initials are used in the pleadings or in the briefs. And we have a number of termination of parental rights cases. In those cases, and I see many of the litigators here today are familiar faces. Everybody knows what I'm going to say next. If you have one of those cases and you're referring to a complaining witness or the termination of parental rights, please refer to those individuals by their initials or by their, whatever pronoun or acronym you want to use, but not by their first full names. And the reason is because these matters are public proceedings. They will be recorded and they'll be available on the internet. I guess for however long things are available on the internet, which I think everybody assumes is in perpetuity. But at any rate, those are sort of the rules of the road. Go ahead, Judge.
I was just going to apologize for not being there today. It's the first time in 24 years I haven't been in the courtroom for arguments excluding the pandemic. And like I said, I hope I will be there tomorrow, but I apologize to the attorneys, and believe me, I would much rather be there.
The reality is, and I won't go into great specific details, but it's not because Judge Murray's choosing to. It's because it's a courtesy, because I have a family member who has some pretty serious health challenges right now, and other things are going on. And out of courtesy to my responsibilities, my family member, he's doing something he hasn't had to do in 24 years. So, Chris, I thank you very much for that. Your generosity and kindness is appreciated. So, with the cases, you don't need to read the briefs to us. If you start doing it, it's probably not going to last real long. But we look forward to your presentations. Judge Rick, anything you want to add before we get started?
No, just lovely to be here with all of you. And Judge Murray, I look forward to seeing you tomorrow.
Yes. And it is 3 UAD law grads, by the way, on this panel. So
Go Titans.
Go Titans. All right. Okay, we'll call the first case, and that is case number 1. People of the State of Michigan versus Nicholas Hunter Mew. Endorsed for oral argument is the defense. The prosecution is not endorsed. So if we could proceed. Anybody here? I think that, yeah. I think that's Mr. Nolan there. Good morning. Long time no see. Yeah, how you been?
Great.
How's your brother?
He's excellent.
Good. Good. Tell him I say hi.
I will.
Thanks. Okay, please proceed.
Your honors, first of all, I'm appearing here with Andrew LaPrey from my office because he was the trial lawyer on the case, and he might be more helpful in answering some of the questions at the time that the case was tried. I think the law is pretty well established in these areas. And, our big argument here is the proportionality. And there are some things that we think that are really important that the court never took into consideration. And one of these things, it's hard talking like this.
It is.
But one of the things that we believe wasn't taken into consideration was the offender. He put all of his weight on the offense itself. And let's talk about that first. So he says that the Judge Trusak says that what happened here is they didn't consider in the guidelines the dollar amount in this case. And what we're saying is he didn't consider the offender in this case. And certainly the strengths of the offender and the fact that we believe all the restitution's been made. Now, on the record, my client technically would still owe money, but these were MPERCs. And I had an opportunity this morning to just look at some statistics from Meyer that's on the internet. That Meyer themselves reported that only about 20% of these get used. Now, he got hit for $1 million in restitution, but in reality, he never spent the money. He saved it, he invested it. He himself got about $450,000 with the investments. He ended up paying back $611,000. I think Meyer's going to wind up with a windfall. So he's saying that.
Hopefully they pass that on to their customers whose accounts were drained.
I mean, they have a liability of 1 million.
But they gave him back. They gave him back the money. There was only one victim, Meyer. There's only one victim.
And they had a liability because of the activities of your client,
Right.
$1,087,168. Do you
But they
agree on that?
didn't give him back in cash. They gave him back in MPERCs.
Do you agree that there was a liability created because your client stole
Yes.
$1,087,168, sold it on the dark web to people and entities we don't know? 29,000 Meyer customers were affected. Fair?
But they were all reimbursed.
Okay. Well, your client.
And then Meyer was reimbursed.
Your client paid $611,000 in restitution.
Correct.
But on the restitution order, there's still $476,168 left.
And here's what Meyer said. Meyer said, you know what? Here's what we're going to do. We're going to leave the investment account there. And at the end of the term of probation, if the investment has grown to that, you don't owe anything. They worked that out. They were very satisfied with getting $611,000.
Well, any of us who've been lawyers for more than a
Right.
minute, in a fraud case, there's almost never restitution. But this one there was. But right now, there's $476,000 of restitution owed.
Right.
And the other issue that just is frightening is the concept that your client not only engaged in this conduct over, I think, a fairly significant period of time, but they were consumer accounts that were drained, and that information went on the dark web. And there is no restitution on the dark web once any personal information or, are shared. I mean, I don't think it's as simple, counsel, as we're going to reimburse Meyer.
None of these people's personal information was revealed to anyone except for their MPERCs password. That would be it. My client didn't even know their names.
And that password could be used and an algorithm applied and it can lead to other accounts. It isn't just as simple, I guess, I'm pushing back on the notion that Meyer's going to be satisfied and so therefore case closed. I think there's a lot of other conduct that went on and ramifications that, in my mind, Judge Trusak took into account.
I didn't see anywhere in the sentencing where he took into account any positive factors of my client, which
I think that is not an accurate reflection of the transcript of sentencing. I read it. He talked about the defendant's age. He talked about the 15 letters of support that he got. He specifically articulated this on the record, Mr. Nolan.
but he didn't take them into account.
You'd say he didn't take it into account because he didn't give you the sentence you wanted. I mean, a trial court judge says, okay, I've reviewed this. I've considered, I understand he's X years old. Do you have to then say that the remaining participle of the sentence? And I have taken that into consideration. If you're not taking it into consideration, why on earth would you even mention it?
So we got a guy with guidelines of 12 to 20,
Right?
who's for 18 months. I think this went on for a little over a year and a half.
Right.
Okay. So when he started, he was 20 years old. We also, during the trial portion of this, Judge Trusak was aware that this was someone brought up in a home where the parents didn't speak English. It was brought out to him that he was a loner, that he did most of his friends on the internet, and that's how he communicated with friendships. He never could talk to his own parents. They never learned English, and he never learned Chinese. He had to learn himself growing up. His parents still can't speak English. The restaurant's right down the street from our office. They cannot speak English. He cannot speak Chinese. This is it. So these are things, and this happened during COVID when his only outlet is the computer.
He stole 54 times the amount that the sentencing guidelines takes into consideration. He still owes 23.8 times the amount scored in the sentencing guidelines. And the sentence was 5 to 20 years. It was a 40-month upward departure, which is obviously substantial. But it's not a 10 or 2/3 situation or anything remotely close to that.
Your Honor, it's still a property crime. I've represented homicides where the sentence isn't 5 years. I mean, I don't know how many manslaughters I've handled where the sentence is in the 2 to 3 range. So killing someone, he got sentenced double some of those. I mean, you would have added 65 points to the OVs to get to this kind of number. 65 points on the OVs would have to be added for this to get to 5 years.
Analogy was helpful in your pleadings to put it into context.
And here's the other thing. His background, no prior criminal record, no prior adult, juvenile. Here's another thing we have to take into consideration. Asking for nothing in return. He met with the state police and the people from Myers and spent 2 afternoons with them, showing them how he did this because how he was doing it was so complicated. They couldn't have figured it out without his help. He got no consideration for that. He got triple the max of the guidelines. He got no consideration for all his helpfulness in this case. Nothing. Now, he can mention whatever he wants, but I don't see where he took into consideration any of these. He didn't take into consideration the 15 support letters. Just because you mention it in your sentencing doesn't mean you took any of it into account.
But you understand, counsel, it's not incumbent on the trial court to comment on every single piece of evidence that is brought before it when fashioning a sentence. He referenced that he did. So I think there's a disconnect in saying because he only referenced it but didn't expand upon that it's the defendant's burden here, right, to demonstrate that there is a basis here for the relief you're seeking, and I'm not sold, unfortunately.
Your Honors, this comes down to not only the offense, but the offender.
Absolutely.
And I don't see where, I can't see anywhere in there where any deference was given to who this kid was and what he had done. Now, he did everything he could to rehabilitate himself and to start the rehabilitation process. He did things I rarely see in one of my criminal defendants. When the police are there at his house, they do a search and they're going to leave, and he says, listen, there's $20,000 you didn't find, and goes to something under the floorboard and gives him another $20,000 in cash. He didn't spend the money that he made. He gave back what he had. I mean, the only expense that he did out of the money that he took or that he gained, he paid his rent in advance. That was it. He paid some rent in advance. He didn't go on a lavish trip. He didn't take a vehicle. And then he did everything he could to make it right. He paid the restitution, everything he had. He gave him every dime he had, even money he had hidden. He went under the floorboard and got it for him and handed it to him. He has tremendous letters of support. He was a great student. This is somebody that clearly could be rehabilitated. And that's one of the factors. I don't see how that was taken into effect. I mean, this is a guy with no record and triple the max guidelines. I mean, I know the old standard was shocks to conscience, but certainly it would have met that. And I know that's not the standard anymore. But I think even the Attorney General was shocked at this sentence. Now, they're not here. They're not arguing. They didn't submit a brief. I'm not sure they're even objecting to what we're doing here today because they themselves, I think, were shocked at the time of the sentence. But I rarely have had a better client than Nicholas Mui. And, you know, just adding to this, went to the prison to visit him. You could tell he was extremely popular with the guards. And he's doing computer work for them at the MDOC. I mean, this guy's doing everything he can. He is not a threat. He's not somebody that needs to be locked up for 5 years. I mean, that's the...
I understand your position and argument. It's heartfelt, the manner in which it's presented with passion, and I have great respect for you and your firm, and we will consider it. Is there anything else? And we certainly appreciate the excellent brief. Anything else you want to share before we submit the case?
Well, one thing that I did notice when I was reviewing for this that I missed at the beginning is in the there's a mistake, Your Honor, on or Your Honors, on the table of contents. It says number 1, and down at the bottom of the first paragraph, it says a majority of the restitution owed defendant's cooperation, assistance to the police, his lack of misconduct. It should have been on bond. The word bond was left out, and I missed it when we submitted it.
Thank you. Thank you, Mr. Nolan. It's nice to see you.
Nice to see you, Your Honor.
Counsel, for trial counsel, thank you for being here as well. This matter will be submitted.
Thank you. Thank you, Judge Marine. I'm sorry I didn't get a look over there that way.
You know, that's fine. I was just going to say for the other lawyers there, I can see the way the camera angle is. When you're just addressing the panel, I can see you fine. So no one has to worry about turning over to the screen and looking at me.
Well, thank you. And thank you, Judge.
All right, thank you.
Have a good
All right,
day.
have a good day.
Well.
Matter is submitted. Next call, People of the State of Michigan versus Adam Ray Aaron Todd, 370908. Attorney Catalino is endorsed for all.
Morning, Your Honor.
Morning.
Morning.
Your Honors, excuse me. As I'm well aware, always when I appear before the Court of Appeals, I'm well aware that you've read the materials that have been submitted. I think that we briefed the matter thoroughly. I'm appearing mostly to answer any questions the panel might have. I do note, though, and I'd like to note for the record, that the prosecution did submit a brief in response.
Mm-hmm.
I was rather surprised, I guess, that the brief did nothing more than reiterate the law, which seemed to be consistent with the position we had taken. The prosecution never addressed the facts of the case or the inadmissibility of the evidence that we claimed. And then lastly, I'd just note that their request for relief did not even oppose the relief we had asked for, but left it to the discretion of the court, which I think is a standard anyway.
Pretty sure it's a decision. Yeah. That was what they told me at New Judges School.
That's what I've always believed, but anyway, those are the extent of my comments. I think the evidentiary issues were very convoluted in the course of the trial, and that's why we tried to brief it thoroughly.
May I ask you a question about one thing?
Yes.
At page 136 of the transcript where the jury is being charged, so it's after the oral arguments have been made, the trial court gives the inconsistent statement instruction and talks about, you know, the different ways that it can be used. As you know, and all three of us as trial judges know what the instruction is. Did that instruction remedy the defect as related to Mr. Warren's out-of-court statement about the, the things he's going to do and, the Facebook, the fake Facebook entry or however you want to call it.
I don't believe it did, Your Honor. I think that by the time they reached that point of the instructions, all of the damage had been done. It had been excluded, as the court's aware,
Right.
previously. And the trial judge vacillated throughout the trial, in my opinion. And I don't think you could rectify it with a jury instruction.
Do you agree in principle that under 613, I think B, that if you give a witness on cross-examination the opportunity to explain a prior inconsistent statement, that there are circumstances where you can use extrinsic evidence for impeachment purposes?
Yes, I think that I would agree that that would be the state of the law. Yes.
But the way it was done in this case, you think was so defective that it should be a new trial?
Yes.
Okay.
No question.
Judge Murray, any questions? All right, counsel, thank you. Very good brief. It was very well written and thoughtful and
Thank you, Your Honor.
help organize facts that were not always straightforward. Sir, thank you.
Thank you.
All right, the matter is submitted. The next case is People of the State of Michigan versus Jeffrey Carl Wade. For the defendant is Mr. Ambrose, and for the plaintiff is Ms. Bloomquist. This is the case Mr. Lakey did the brief on, right? God rest his soul. He was in front of me so many times at 17th Circuit. I'm just a wonderful guy, great advocate. And thank you for picking the case up after his passing. So
Yeah, it's probably the hardest thing that I have to do is, when I get a case, and for the record, Ronald Ambrose appearing on behalf of Mr. Wade, is to, start from the beginning. When I'm in the case, it's a lot easier to,
yes,
as you progress and then kind of refresh your memory as you get closer to oral argument. But for my purposes here today, I'd just like to concentrate on the first two issues that were submitted. And what I found striking was that the charge itself is really, it's only one count. It's count one, but count one is kind of merged. The way that the prosecution has pled it, it's kind of merged two distinct acts of criminal sexual conduct into one count. And the jury was never asked to separate those two as to what actually was Mr. Wade guilty of. Was he guilty of the part where the child is under the age of 13? Or was he guilty of the other avenue of between 13 and under 16 and living in the same household? So that's, I thought, a pretty significant point in the whole case, because there is a requirement of having a unanimous verdict. And in this situation, we don't know what the jury found. So the second thing that I wanted to touch base on was the vouching.
Can I ask a quick question, Mr.
Yes.
Did trial counsel agree to the jury verdict form?
Yeah, he did. And there was a subsection in the brief that calls for ineffective assistance of counsel. And
What do you think a correct verdict form would look like in a case such as this?
I think the way that it was charged is the problem. Because it really should be two counts. Count one, under the age of 13. Count two, 13 to under 16. But it's all in one count, and it is two distinct charges under 750.520B1A, I think, and B subsection 1 delineates what the two charges are, and they have different elements.
I see. Thank you.
With regard to the vouching issue, what I wanted to concentrate on is the prosecution statement at the time of what I find often is in rebuttal, because at that point, trial counsel doesn't have a chance to get back up and say anything about what has transpired. So in this case, and I'm not revealing any names of minors here, Savannah is the sister. Yeah, spouse and
Of the
sister.
defendant.
So what Savannah is saying doesn't make sense. The only reason that Jerry is here is because it's true and it happened to her. This is what happened to her. She has no reason, absolutely none, to sit here. She lost her sister. She lost her sister out of all this. She didn't gain her sister out of this. She lost her sister. She lost her niece and nephew, which are the most important things to her. And then it goes down another paragraph or so. So if she's going to sit here 2.5 years after she called the police through COVID, when the courts are finally open, back up and sitting here, it's because it's the truth. This is what happened to her. She lost almost everything, a huge piece of her because of this. She's telling you the truth. She's telling you what happened to her. Well, the prosecution is not a lie detector. I mean, all of that is up for the jury to determine. And that just feeds into sympathy for the victim. And I think it's unconstitutional vouching.
Any other questions for our counsel? All right, Mr. Ambrose, you have time for rebuttal.
All right, thank you.
Thank you.
Good morning, Your Honors. May it please the court. Heather Bloomquist on behalf of the Muskegon County Prosecutor's Office. Jumping right in here to issue one, I think that the jurors were instructed properly. The verdict form was proper as it relates to this specific case and these specific allegations. Now, one thing that I point out in my brief, and I think that takes this case apart from some of the cases cited by opposing counsel here, is that there was a blanket denial. And there was nothing that materially distinguished any of the alleged sexual contact or sexual penetration. So specifically, and I'm looking at page 14 to 15 of my brief, People versus Cooks, 446 Mish at 512 through 513. A specific unanimity instruction is only rarely required when there is whether either party has presented evidence that materially distinguishes any of the alleged multiple acts from the others. Here, the defense was, she's fabricating this, it's entirely made up, and my client did none of it. And that's directly opposed to the victim recounting what happened. And looking at what the jurors were then instructed and charged with, it was, did a sexual penetration occur of another individual with these aggravating circumstances, those being the two that were enumerated in the statute.
I wonder if you could address, though counsel has raised the issue of age, right? So under 13 and 13 to 16. I mean,
Yes, Your Honor.
can you address why that difference was not either laid out in the instruction or why it doesn't matter?
Well, Your Honor, and I believe that that's sort of the following paragraph on my brief, which is that that those sorts of factors, albeit specifically separated by the statute, they don't make an effective difference because it's a violation regardless of CSC 1 under the same statute. Those are sort of subsets of the same the same thing, which is that this is a qualifying other individual under the CSC1 statute, regardless of if she's only under 13 or if she's 13 through 15 residing in the same household. And I think particularly looking at this case, this individual resided in the household the entire time that the alleged penetrations occurred. This was, for all intents and purposes, a stepchild, so to speak, not legally, but in effect, this was a child under his care and control in a pseudo father type role. So I think looking at that, I get the court's point. This absolutely could have been cleared up in a separate instruction, but that dovetails into my counterpoint for this ineffective assistance of counsel argument, as well as the waiver argument, is if it had been pled separately, he'd be facing 2 separate counts of CSC1, as opposed to the one count that he was in fact convicted of, which, as your honors all know, as trial judges, that would impact PRVs, that would impact OVs, scoring of guidelines. And so I think that there is a reasonable strategy to say, hey, let's hold off on making this objection because we could talk ourselves into an additional count. And one of those counts, I'm trying to see it in my memory if he would qualify, but could potentially carry a mandatory 25 sentence as well. And that wasn't pled in this case either, to my knowledge. And he wasn't sentenced to a mandatory minimum 25, but.
Well, just as an aside, it's also not uncommon for there to be testimony about multiple counts in a CSC case. And yet the people don't always charge each and every count.
Correct.
Mm-hmm. Can you address the vouching and the misconduct in air quotes?
Yes, Your Honor. Specifically, and I think there's a quote, and I don't know if I put it in my brief here, but there's, a trial is not a basket luncheon where everybody's just having a lot of niceties to say. And prosecutors are allowed to make vivid arguments as long as they're swinging above the belt. This was all above the belt. Every single inference or every single assertion by the prosecutor on this case was directly tied to the evidence that was presented. The victim in this case testified to what this has done to impact her life, how her dynamic in her family has changed, and how that was actually one of the reasons for her delayed disclosure. Every instance in that closing argument, when looked at in context and in relation to the defense arguments that were raised, it was fair. It was not vouching. It was a fair inference from the evidence that was presented, particularly in light of the defense that this was a fabrication. And so I think given that, and for the cases that I cite in my brief, it's not plain error. And I'm happy to answer any other questions the panel may have.
I have a couple.
Okay.
Did the defense move for a bill of particulars in this case, if you know?
I don't believe so.
Right.
I don't.
Is it your position that so long as the jurors believed that an act of sexual penetration took place without consent, and they were unanimous on that, you could have had 6 jurors believing some evidence of some event when she was under the age of 13, and 6 other jurors maybe not believing that, but believing that something happened between when she was 13 and 15, and that the defendant and the victim were members of the same household.
Yes.
And that's not constitutionally infirm from a unanimity of verdict perspective.
Correct, Your Honor.
How can that be?
Well, Your Honor, I think when we're specifically looking at the statute itself, it's those, I believe, reading plain language, the circumstances are modifiers for the other person. Is the other person at the time of these sexual penetrations, is that person existing in those circumstances covered by the statute? So I think that the defendant would be on fair notice that they would be that is criminal conduct. If we're talking about a due process type argument from that. But I'll circle back to this too, Your Honors, is that my first argument, and the court's aware of it, is that this was specifically agreed to by an express agreement to the jury.
Right,
verdict and
your
the
position,
instructions.
it's not just, it's abandoned. That the defense agreed with this. You can't now use this as an appellate parachute.
Correct.
Okay. We'll have to channel what Mr. Ulecki would have argued, as well as Mr. Ambrose. So, all right. Anything else for counsel? None indicated. Mr. Ambrose, anything else you'd like to share with us?
No, I think I stated what I needed to state.
Okay, and thank you.
These are two separate.
Yep. The court's very appreciative, Mr. Ambrose, you're picking this case up
Thank
after
you.
our friend, Mr. Ulecki passed, a year and a half ago. So thank you for doing that. The matter is submitted. Court next calls case number 4, People versus Randy Paul Kirk Jr. Endorsed for oral argument are both the prosecution and defense. I believe it's Robert Reilman for defense. Anybody?
He's supposed to be.
Who is? Mr. Reilman? Oh, okay. And sir, you are?
I am Robert Rahman.
Oh, hi.
I believe,
Mr. Morton.
yeah. you do.
Okay. All right. There's, yep, I recognize Mr. Morton. Mr. Reilman, good morning.
Good morning. May it please the court.
Thank
My
you.
name is Robert Rahman. I'm representing the defendant, Randy Cook. I know the court has read my briefs. I won't rehash every single point. I do want to respond briefly to the prosecutors or the attorney general brief about the term mass shooting and some of the other terms used in the prosecutor's closing and opening argument. I know the attorney general gave 3 definitions of what a mass shooting is. Most of them are federal, and most of them are different. I think that alone is problematic of why it's what a prosecutor even use at a trial. It's also not even defined in jury instruction.
May
And I
I
think-
stop you? May I stop you on that point, counsel? Because it seems to me that when you have, was it 17 shots rendered at 2 different locations? I forget if it was 12 or 17, but that's more than having a desire to shoot at a particular person. And I mean, the number of shots seems rather extreme, and to forbid the people from arguing the potential of a mass shooting under these circumstances at a in the street and then near the dollar store, I think. But help me understand why the number of shots does not have bearing on the language used by the prosecutor. Why do you take issue with that?
Well, for one, I think the prosecutor, he wasn't charged. There's no crime of mass shooting per se. There's a crime in here and he would charge with 1 count of assault with the intent to kill 1 person. And so there's multiple shots, sure, as has been shown throughout the trial. But we're talking about the intent to kill 1 person. And I think going back to my point about the mass shooting, well, the fact that there's multiple different definitions is problematic. You're going to have a jury that's probably not very clear what that means. And then I think the prosecutor is clearly, in my mind, appealing to the public perception of what a mass shooting is and not what might technically count as.
Tragically, we all have been touched by gun violence, whether it be watching on the television or otherwise. So I appreciate that argument, but a mass shooting is not a legal term. So again, what's wrong with those words, given the
Well,
number of bullets?
So again, there's multiple definitions there. There's not a definition that was given to the jury and said, this is what that means. I think I think a jury can have different opinion about what might constitute a mass shooting. And I think what the prosecutor is doing in this case is just, he's alluding to what we all would recognize as mass shooting, and how negative that might seem. He's appealing to that. And it was completely unnecessary to try to prove intent to kill. You're talking about 1 person. I'm sure in a real something that's unquestionably a mass shooting, you have multiple counts of assault and kill, or even, God forbid, murder. And then we have the reason to do it, but you have one person here, and he's saying he's not letting the facts, the evidence itself speak for the intent. He's appealing something extraneous to that, which is this very negative perception. Why was that necessary to appeal to that? He uses the word rampage and hunting humans. Again, I think there was a definition of rampage taken out of Webster's dictionary. Okay, a lot of crimes can fit that bill. But I think, again, the prosecutor is making that appeal to something very negative. And that's why it's presidential and unfair.
It did seem like he was having a mental crisis as opposed to deliberately. I mean, that was part of the defense, right? That he was having a mental crisis.
I'm sorry, can you say it again?
That he was having some kind of mental crisis, to your point about specific intent here. Or hunting, which in my mind, again, not a legal term, but suggests a deliberate action to it, my husband shooting the grouse as it flies up into the sky, right? And that your client lacked that mens rea.
Correct. And I think when he's using hunting humans, he's again making a broader appeal to something very negative. We're not talking about you just happen to be hunting one person or literally like a hunter and doing what hunters do.
I think that the arguments that you present have much more currency if it's not at two different locations. That's the troubling part for me. And then the question becomes, how much leeway should the trial court and or the reviewing panel give the prosecutor in arguing the facts and evidence? Because the shooting starts one place, then there's a car that gets followed and shootings more at the dollar store. That's the part that I think is a difficult path for you to navigate.
Well, I understand that. And again, my argument will be if it's something that's in the jury instruction, something that's in the elements of the crime to be in charge, then it would be a fair inference for the prosecutor to make based on, the multiple locations. But the charge that I'm focused on is the assault with intent to kill. And it was one person. He wasn't even charged with intent to kill the daughter within the car. And I guess I'm thinking he didn't have probable cause even.
Okay, no, thank you. That's helpful. I remember as a trial judge, sole intent to murder. I mean, you must prove beyond a reasonable doubt that had the defendant been successful, it would have been murder. That's what they wanted to achieve. The specific elements of it as articulated in the jury instructions are quite substantial. So, but that's helpful, that comment. Thank you.
Okay. So again, I just wanted to respond to that. And personally, I'm bothered by that appeal. I don't pretend to have a very intuitive sense of what's fair in a trial. I have trouble reading the case law and trying to understand that, but this, to me, it seems pretty problematic. It's just in a perfect world, when we do a trial, we want just the facts to come out. We want the lay witnesses to talk about the facts, don't give the opinion, not unless you're an expert and they're qualified, and let the jury decide that. And not interject all this negative connotation. So I think it's just really good grounds for this court to reverse and remand back to the court. Thank you.
Okay, thank you. Judge Rick, anything else?
Nothing for me, thank you.
Judge Murray? All right, thank you, sir. You have time for rebuttal if you'd like. All right. And then Mr. Morton, you're appearing next to Judge Murray. Are you in the same building or what's going on here?
No, Your Honor. May it please the court. First of all, is my mic working?
Yes, perfectly.
Okay, thank you. May it please the court. Assistant Attorney General Brent Morton on behalf of Cass County. I don't know what side Judge Murray is. I'll try to look over.
Just look into your camera. We'll be able to see you.
Awesome. Thank you. With regard to the prosecutor error claim, opposing counsel is unhappy because it's a very negative explanation of what his client did, but it's an accurate and common explanation. Is he's along the road shooting indiscriminately at passing vehicles. Thank God he didn't kill anybody there. Mr. Colpritz follows him, and defendant gets in his car and he goes to a place where a bunch of people are. He reloads his weapon and he goes into the store. He gets out of his vehicle with the intent of going into the store with his weapon. So, indicating that this is a mass shooting incident is pretty accurate. Indicating that he's on a rampage is pretty accurate. And indicating that he's hunting humans, shown by him changing location where more people are, reloading his weapon and having his weapon with him, suggests that he is hunting humans. The focus shouldn't be on whether or not it's negative. Prosecutors gets to argue the evidence, and the evidence usually isn't very good for the defendant. It's usually pretty negative for the defendant. The focus should be on whether or not there was evidence where the prosecutor could reasonably make the argument. And I believe that there's plenty of evidence here for him to use those common terms. On top of that, he didn't lead his theme, or she didn't leave her theme out with the mass shooting. It wasn't constantly brought up. It was mentioned. I think each of those terms were mentioned once in the argument. And I don't think that's outrageous, considering what the defendant did.
You addressed the second argument, Mr. Morton, the specific intent, the assault with intent to murder, and whether there was sufficient evidence on the record. Counsel's just argued 2 of the 3 issues that he raised on appeal. Can you address that one?
Okay, the sufficiency. I think as I ran through a lot of that, but when he saw Colpritz following him, he stopped, he got out of his vehicle and he shot at him. He hit the vehicle. And I think that shows the intent. I think the shooting at vehicles before and after shows an intent, and the reloading the weapon and shows an intent that he wanted to kill someone. That's what guns are for, unfortunately. So I think that taking everything into account, which the jury could do, I think there's plenty of evidence that he intended to shoot Mr. Colpritz so that he didn't follow him to the store where he was going to continue his rampage.
Thank you. And I suppose you think that the sentence was proportionate.
It's within guidelines. It's presumed proportionate, and there's nothing that unique has been offered by defense to overcome that presumption. So I believe a within guidelines sentence is proportionate, and I think it's appropriate.
Thank you. I have no other.
All right, thank you. Anything else, Judge Rick?
No, thank you.
Judge Murray for Mr. Morton. All right, thank you, Mr. Morton.
Thank you, and thank you for allowing me to appear remotely.
You're welcome. Mr. Rauman, any rebuttal?
No.
All right, thank you, gentlemen, counsel. Well briefed, well argued. The matter is submitted. Court next calls our 5th case on our docket for this morning. People of the State of Michigan versus Ted Anthony Meyer. We have 4 counsel on my notes are endorsed for oral argument. We don't get 4 arguments. Sorry. Okay.
Good morning, Your Honors.
Morning.
Gabrielle Barber from the State Appellate Defender Office here on behalf of Mr. Meyer. I am also joined by Mr. Meyer in the courtroom and his mother today. So.
All right, Mr. Meyer, welcome. Mrs. Meyer, or your mom, welcome as well. Ms. Barber, you may proceed.
Thank you so much. This case is about credibility. It's about the credibility of a regular person minding his own business and tending to his property versus the credibility of his county's assistant prosecutor with all of the power and assumptions that come with that. Each of the errors that we've argued in our brief goes straight to the credibility of this case. Improper statements and testimony from the lead investigator, straight to the credibility. Repeated recognition of the complainant in this case as the county's prosecutor goes straight to the credibility of this case. And Mr. Meyer's statements made during a 13-minute interrogation while he was surrounded by police officers at the end of his driveway went straight to the credibility. Individually, each of these errors entitle Mr. Meyer to a new trial. However, the cumulative prejudice of these errors also entitle Mr. Meyer to a new trial. I want to use my time to make a couple of points about the first two issues that we've raised, but I'm happy to answer any questions that this court has at any time. I'll start first with the ineffective assistance of counsel issue for stipulating to the admission of this entire interrogation video and for counsel's failure to object to Officer Goddard's testimony about the perpetrators of assault tending to lie and hedging all of Mr. Meyer's statements. Now, in a case like this, that's all about credibility, Officer Goddard's statements, both on the body cam and his testimony that he made, were extremely damaging. And this is exactly the type of evidence that our court in Musser sought to protect against. Here, there are relevant portions of the video where Mr. Meyer is telling Officer Goddard what happened from the start. Officer Goddard shows up, asks him why he hit somebody with a shovel, and Mr. Meyer tells him consistently each time Goddard asks what happened, that he did not purposely hit this man with a shovel.
Right, but in Musser, and having been the trial judge, I have a fairly specific recollection, and having been affirmed 3-0 by the Court of Appeals before I was reversed 7-0 by the Supreme Court. So not that I remember the case, but in Musser, the officers were saying, come on, kids don't lie about this sort of thing. This is why, they just don't lie. And Mr. Musser repeatedly, and interestingly, the defense didn't object because strategically they wanted it in, because in the face of that confrontation, he still did not, he said, no, I didn't do it. And the Court of Appeals, Bill Murphy was the PJ. We were both running for the Supreme Court that year. It was very interesting on the campaign trail. We both got reversed 7-0. So at any rate, but in all seriousness, Musser's colloquy by law enforcement, and that the Supreme Court very appropriately, it's the law of Michigan, found to be vouching. That's not, it didn't come really very particularly close, it seems, in this case. So
I disagree, Your Honor, for a couple of reasons. And I do think that not only the video is relevant to this question and to Musser, but also the testimony that Goddard offers at trial too. So Goddard, I think too, also the context of his statements to Mr. Meyer matter too. Because when he first starts talking to Mr. Meyer, he asks him what happened, and then Mr. Meyer tells him his story. And he's very straightforward and tells him what happened, right? And Goddard, the way he starts asking Mr. Meyer what happened, he's, why'd you hit this man with a shovel, right? From the beginning, he is pointing to Mr. Meyer and to everybody who's listening and the jury that he doesn't really believe whatever Mr. Meyer is about to tell him. And then when Mr. Meyer tells him, he continues to push him. After Mr. Meyer has repeatedly denied this allegation that he purposely hit the complaining witness with a shovel, then Goddard offers this hypothetical where he says, okay, there are two types of reports I can write. I can write a version, which is, where Mr. Meyer is telling me the truth and he's cooperating, blah, blah, blah. Or, I can write this report where he's lying to me and he's not being truthful. Implying, again, he doesn't believe the version of the story that Mr. Meyer has told him. And so again, he's pushing Mr. Meyer to tell him the version that he thinks is correct, which is not what Mr. Meyer's been telling him. But again, Mr. Meyer repeats that the same version of the story that he has from the beginning, right? And so that to me looks a lot like what's happening in Musser. But also, you have the type of testimony in Musser where the officers are saying, just generally, kids don't lie about this stuff, right? And Goddard has the same kind of testimony at trial where he's asked by the prosecutor, in all of the assault investigations that you have done throughout your experience, do people who assault other people tend to lie? It's maybe not exactly it, but pretty close. And he says, yes. That is also reminiscent of what's going on in Musser and what was not allowed in Musser by our Supreme Court, because this is this generalizing that people like Mr. Meyer who are accused of assault are lying. And then you also have Trooper Goddard's testimony at trial where he is hedging everything that Mr. Meyer has told him during this interview when he's being asked about, what did Mr. Meyer tell you happened and blah, 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 and what happened to the shovel and all of this stuff. And he's saying, well, allegedly, or I'm forgetting the other hedging word he uses, but he's hedging everything that Mr. Meyer is telling him. Whereas when he's repeating what the complaining witness tells him, he's not hedging any of those statements, right? He's just telling them as if they're true and as if they're fact. All of these things combined signal to the jury, just as in Musser, that Mr. Meyer is lying, he's not truthful, that they should believe this officer who, again, right, we recognize that officers, when they testify, regardless of the jury instruction, do just have a little bit of extra credibility by juries, right? And so you're hearing from this neutral officer who was called in separately because he doesn't know this prosecutor that has this type of experience of investigating 50 to 75 assaults at that time. Generally, these people who are accused of assaulting are lying, and then hearing all of these different hedging words and accusations against Mr. Meyer for not being truthful. All of that combined looks a lot like Musser, in that it is going straight to Mr. Meyer's credibility.
What's the recording?
13 minutes.
Yeah, that's a whole lot shorter than Musser, I can assure you.
Which is fair, but I mean, in a way,
And more than an hour shorter.
right. But in a way that, I think that,
And I don't know that that's essential, but I mean, it is, it's a lot shorter.
yes, and it's a lot less for the jury to hear, but it's also a lot of what they're hearing in that time. I mean, there's maybe 6 to 7 minutes total of conversation between Goddard and Mr. Meyer, and at least half of that is Goddard accusing him in this, weird hypothetical way of like, Mr. Meyer is lying and not being truthful to me. So while it may not be the quantity of what the video was in Musser, the quality of it, right? Like when we think about the amount of time that the jury is hearing and seeing, it's hearing and seeing a lot of Goddard not believing Mr. Meyer and signaling to them that they shouldn't either.
Having watched the video, though, it's really hard to see how that was custodial. I mean, it took place at the residence. Your client was, free to move about somewhat, because I think at one point there was like, oh, turn and face me or something. But I sell the custodial nature of this interrogation because I think that the video suggests it was not a custodial investigation.
Sure. Yeah. A couple of things, right? So this court analyzes the totality of circumstances. We have to show some sort of coercion or coercive environment by the police. Mr. Meyer's at the end of his driveway. There is case law saying that we don't presume that while at somebody's home, this is a custodial interview, but he is at the end of his driveway. And if you watch the very beginning of that video, it starts where Officer Goddard is walking from his car. You see a couple of other police vehicles kind of blocking essentially the road, right? And walking up. And then Mr. Meyer is accompanied by 2 other officers as well. And so for the entirety of this interview, for all of the questioning, he's surrounded by 3 officers. He can't leave the direction of the road because it is blocked off by, I believe, two police vehicles, but I could be mistaken. And every time he is trying to leave or direct the officers towards the road where they could go and see the ATV tracks, he's told not to move. There's, I think, 3 different incidences where he says, let's go and I can show you the tracks. And Trooper Goddard says, no, stay right here. And he says, okay, well, and he tries to move again. Nope, stay right here, Ted. A couple of times. And so really the totality of the circumstances, you're surrounded by 3 officers. You can't leave the direction of the road if you would like. While you could go home, the officers aren't going to let him go into his house. They repeatedly are telling him to stay right here, Ted. And they're armed officers, again. Totality of the circumstances, a reasonable person isn't going to feel free to leave. And additionally, immediately after this interrogation, he is arrested, which is also something this court considers.
Yeah, I was kind of curious what might have happened if early on he said, I'm not going to talk to you, and attempted to walk to his home.
I mean, frankly, I think he probably would have been arrested. Again, it's a hypothetical, but given the situation and what did happen immediately after talking to the officers, I do think that that's just what would have happened. I did just want to make a couple of points about our second issue as well. Again, this is really about the credibility. This is the issue of referring to the complaining witness as the assistant prosecutor repeatedly throughout the trial. Trial counsel should have objected the moment that this reference is made in front of the jury, maybe even should have filed a motion to eliminate to refer to this complaining witness not as the assistant prosecutor. Similarly as how we talk about officers testifying, and we do have our jury instruction that explains that we shouldn't have juries evaluate the credibility of any different of officers just because they are police officers. We recognize that regular jurors do assign some extra credibility when they see a person in authority, particularly a person who normally is representing them in their county and their interests as the people. Hearing the reference that this complaining witness was the assistant prosecutor in that county immediately gave him credibility when he was testifying and when he was stating his case against Mr. Meyer. And there should have been an objection. I did also want to just briefly make this comparison to, I know Judge Schwartzel made this point in his concurrence from People versus Akins, when we use certain language in court, recognizing the power and the lack of neutrality of certain language. In that case, it was referring to the word victim. But here, we're talking about the word prosecutor. And that carries a lot of weight when it comes to the credibility of the person who is saying something happened against Mr. Meyer.
Was not objected to.
It was not objected to.
So what's the standard of review? What's the prism through which we look at this?
We've raised it as ineffective assistance of counsel.
So you have to show that it's A, it was violative, and B, that but for it, there's a reasonable likelihood of a different result.
Right. Yes. Yes. And again, this is a credibility thing too, right? Like, I do think that this entire case is about the credibility of what Mr. Meyer is saying versus what the complaining witness is saying. And even if this court doesn't think that just that error alone entitles Mr. Meyer to a new trial, we did raise a cumulative error. And when you think about the prejudice of all three of these errors and the credibility impact that each of them have, I do believe that the cumulative prejudice against Mr. Meyer was pretty significant and does entitle him to a new trial.
Okay. Judge Murray, any questions for counsel? Thank you.
Thank you.
All right. Plaintiffs.
Good morning. May it please the court. Assistant Attorney General Daniel Kelly on behalf of the Crawford County Prosecutor's Office. Now, I did not draft this brief. I'm appearing only for oral argument, which, as I'm sure you're aware, can make things a little bit more challenging. But as I reviewed these materials getting ready for today's argument, I read through the transcript. I read the filings of all the parties, the court's opinion denying the motion for new trial, and watched the video many, many times. Two words came to mind. The first, which is exactly the same as fellow counsel, was credibility. And the second was strategy. And these three main errors argued by Mr. Meyer were not error at all. Based on a review of the record, they were strategy. Defense counsel clearly articulated the strategy in his opening, clearly capitalized on this strategy during each question of each witness for the prosecution through cross-examination, as well as in closing argument. And that strategy was both simple and it was intuitive. And that strategy was, this was never a real investigation. The moment the law enforcement officers learned that the complaining witness was the assistant prosecuting attorney, they stopped investigating, accepted that word as the truth, and assumed that Mr. Meyer was guilty. And this can explain many things that are referred to as error. This explains why the defense attorney would want the entire 13, actually about 12 minutes and 40-second video to be admitted for the jury to show this was not an investigation that took hours. It took minutes. This explains why there'd be no objection to the incredulous nature that Mr. Meyer claims Trooper Guttard treated him with, the disbelief, showing that, well, from Mr. Meyer's perspective, he'd already made up his mind and didn't care what Mr. Meyer had to say. That's why he didn't take a separate photo of Mr. Meyer's ankle where he said he'd been run over by the ATV, why Trooper Guttard hadn't taken a photo of the ATV, why he hadn't investigated the prosecutor to see if the prosecutor himself was under the influence of alcohol. This also explains why you'd want the entirety of that non-custodial end of driveway conversation and interrogation, or I guess interview, to be presented to the jury so they could see all of the investigation from start to finish and could argue this was not a real investigation. It also explains why the reference to the assistant prosecuting attorney was not only by the prosecutor, but the defense embraced it and said the APA, the assistant prosecutor, to show, look, police had already made up their mind. They did not investigate. And what does this all mean? It undermines the credibility of the prosecution's case. Now, I'm not saying this case was undermined, but I'm saying that is the strategy that the defense took. It was a valid strategy, and therefore it was not unreasonable. So the first prong of Strickland, Mr. Meyer cannot meet. And that second prong of Strickland, that being a reasonable likelihood of another outcome, but for the trial counsel's performance, again, we cannot meet it. Faced with limited options, really few options for defense, it appears that the trial counsel took the best option that they had and exploited credibility, tried to undermine the credibility of the prosecution case through this short investigation. I also want to take a moment of my time just to point out, as reviewing the brief, again, I did not write this.
Hold on a minute. Judge Murray, did you have a question? Okay, sorry.
Sorry, Your Honor.
Nope.
I did notice that there was an error at pages 15 and 18 of the prosecution's brief. And I think it really boils down to using a 24-hour clock versus a standard 12-hour clock that we use. Being a military veteran myself, I'm very used to seeing, the 1600 versus 1400 confusion.
My staff, my assistant and I have been together in multiple different jobs, and I still write, the 24-hour clock. She goes, I don't know how many years we have to be together before I'm going to get this. I go, just add 12. It's really easy.
So I'll probably embarrass myself or my wife by saying this, but I set all our clocks in our vehicles on a 24-hour clock, and it drives her nuts.
I mean, why wouldn't you, is what I want to know.
But Your Honor, so on pages 15 and 18, it says 1400 or 1445. It really should be 1600 or 1645. So really 4 p.m. or 4:45 p.m., which really means that Mr. Meyer was not really impeached about when he went to the ER. He said he went to the emergency room at about 5 o'clock when he was released. Well, that's, between an hour and maybe 15 minutes later.
Right.
I want to concede that was not an issue in which he was impeached.
So whoever wrote the brief didn't understand how a 24-hour clock worked. Is that what you're saying, counsel?
I don't know if they didn't understand. I'm sure it was an oversight in the first mention and probably a cite back to it.
Just fun with you. Okay.
Pending the court's questions, though, I do not have anything else to add.
As a former assistant attorney general, I know exactly what you're talking about, taking someone else's brief and showing up and arguing. So well done, counsel.
Thank you, Your Honor.
No question.
Judge Murray? All right. Counsel, thank you. Okay, Ms. Barber?
How much time I have, but I just want to make it
30 seconds. No, you've got plenty of time.
It's always so hard to keep track of time while we're up here.
You have 16 minutes. I don't think you probably need 16 minutes for rebuttal.
I do not.
Judge Murray will fire me from taking the middle seat if I let you go 16 minutes. I'm just kidding.
You got that right.
Well, I just wanted to
take whatever amount of time you need on behalf of Mr. Meyer.
I do appreciate it. Thank you. Just very briefly in response to the prosecutor's points about strategy, trial strategy. First of all, it has to be a reasonable trial strategy. I don't know that it is a reasonable trial strategy.
Why don't you think it's reasonable?
Sorry?
Why is that not reasonable?
Well, separately, I mean, for each of them, trial counsel had to recognize that this was going to be a particularly difficult credibility case. And there has to be a lot of evaluation of the evidence. I mean, he did have some strong evidence of Mr. Meyer's own version of events, like the photos of his legs immediately afterwards, his trip to the ER immediately afterwards. There was plenty to already attack the prosecution's case about what happened without going.
But did those things come in?
Yes.
Okay, so if those came in, plus you have the, hey, this was a sham investigation. How does the combination of them not potentially help Mr. Meyer's cause to try to get the not guilty?
The combination of
Hey, listen, we've got corroboration of what happened. We've shown you visual evidence, we've shown you emergency room documents. And in addition to that, once the investigators found out that it was one of their guys, man, it was all over. And they didn't, and then the 13-minute tape shows that the immediate arrest after he asserts his innocence shows that. I mean, how is that not dovetailing those two things together? How's that not potentially a stronger position to seek the not guilty verdict for Mr. Meyer? It didn't result in that. I get that. But how's that not a reasonable strategy?
Because there was a way to do it without the injury, the credibility injury that did occur, right? What we're saying is that trial counsel should have asked for redactions to that video. That wouldn't have stopped trial counsel from questioning on cross-examination Trooper Goddard about the length of the investigation, his assumptions going into his interview with Mr. Meyer, and this question about, when you went in there and after you talked to him for just a couple of minutes, you thought he was guilty? Yes. That wouldn't have stopped those types of questions and getting to the strategy of, let's target this police investigation and show the jury how biased they were from the beginning and how little of an investigation it was. But all he had to do was ask for redactions where Trooper Goddard is accusing Mr. Meyer of lying repeatedly, and to object to this testimony where he is hedging multiple times and where he is saying that in general, in his experience, people who are accused of assault are lying about what happened. I mean, there is a way of having made the case and using this strategy that wasn't unreasonable and didn't go with these credibility injuries that did occur. And again, there is also a way of having done that without referring to the complaining witness as a prosecutor or as the prosecutor. Because most of the case that he was making wasn't necessarily making this
Was
argument.
the complaining witness the elected prosecutor or an APA?
Assistant prosecutor.
Okay.
Yeah.
I don't think it makes a difference, but I didn't see anything that said it was the elected prosecutor.
No. And during voir dire, that was a distinction that was made in the questioning, was that they were asking if any of the jurors knew, any of the assistants of the elected prosecutor. But for purposes of our argument, that doesn't really matter, as you say, right? Because he's still getting the credibility boost from being the county prosecutor or the assistant prosecutor in the county. And counsel's case against the prosecution's case didn't necessarily make this connection about the complaining witness's role in terms of the actual offense. There really was no argument other than his responsive reference to the complaining witness as the prosecutor, only after prosecution was making this point and arguing that in opening statement. And so really that was a responsive strategy as opposed to the primary strategy. So for all of those reasons, there is a reasonable strategy going forward that didn't include these pieces of evidence that really in such a close credibility case were so prejudicial against Mr. Meyer. I would also just ask that, it's one thing for us to guess about trial counsel's strategy. There's another where we would ask, for remand to hear from trial counsel as well, because we don't want necessarily to presume trial strategy as our law says. So those are the only points that I had. But
Okay, Judge Murray. All right, thank you, counsel. This matter is submitted.
Thank you.
Shall you be able to keep going?
Sure.
Okay. Next case is People of the State of Michigan versus Gary Lee Strauss. It's number 6 on our docket today. Mr. Kelly appears again. Then Ms. Walsh.
Good morning, Your Honor. Susan
Morning.
Walsh on behalf of Gary Strauss.
It's nice to
Hi.
see you in person.
Yeah, it is. I was
Oh,
just gonna
Usually
say.
we
Yes.
see you on the screen.
I know it's a long drive out here, but it's nice weather now.
Yeah, I was gonna say,
There you
I'm
go.
glad we gave you some
Yeah.
nice weather,
Kind of.
blue sky,
Kind of nice.
little windy.
weather. So,
Did you come over
Yes.
this morning?
yes,
Okay, good.
yes.
Thanks for
And
making the trip.
yes. And as far as Mr. Strauss, I think that he was very forthcoming to the police. He walked right up to them. Oh, no, I don't think there was any, nobody saw him put a gun anywhere. He admitted to what he had done. He admitted to his wrongdoing. And so I just don't think there was sufficient evidence of a felonious intent to take the gun and keep it. And then the prosecutor, when, met with the plausible argument of, that Mr. Strauss made when he testified on his own behalf, really started badgering him and asking the same questions over and over again, and they were objected to. And I think that he was prejudiced and that denied him a fair trial. And then I've also argued that the top of the guidelines sentence was disproportionate based on Mr. Strauss's background, his poor upbringing, his addiction issues and whatnot. So unless the court has any other questions, I would rest on my pleadings.
Okay. As always, they were very informative and very helpful. Thank you, Ms. Walsh.
Thank you.
Mr. Kelly?
May it please the court.
If you made it over, how come Morton couldn't make it over? That's, I want to know. And Ms. Walsh came from clear over in Oakland County or something, I think.
Your Honor, I can ask him and report back if you want supplemental briefing on that
You might
issue.
have to have a show cause hearing on it.
As a former Assistant Attorney General, I can state without question, there are several other cases going on. He could have to be in
Okay.
another court, so I'm going to have his
All right,
back on
way
that
to
one.
back him up.
Thank you for the benefit of the doubt.
I used to let counsel from the AG's office appear first on my docket because I
Oh, wow.
had a litigation docket and I knew what that involved. So
Very
She was a
considerate.
lot nicer than I was as a circuit judge, I can assure you.
Well, for the record, Assistant Attorney General Dan Kelly again, appearing this time for the people. This time I did draft the brief, so I'm more comfortable answering any questions. But really, I only want to make one point on this, and that is with respect to issue number 1, the sufficiency of the evidence. There is absolutely substantial evidence to meet the element of intent to permanently deprive Mr. Clifford of his firearm. And really, the most important and worst evidence, I think, for Mr. Strauss appears on jury trial pages 57 and again on 59, where when the responding officer asks Mr. Strauss, did you intend to take the firearm? He initially said yes. Now, he later hemmed and hawed a little bit about whether he actually said wanted to, then changed it to I don't know. But by stating, yes, I intended to take it, that allowed any reasonable juror to infer from that reasonably that that intent was to permanently deprive. Additionally, based on all the other circumstantial evidence in this case, his intent to hop the fence to find items of value so that he could, I guess, buy gas for his truck, I guess was his story. And that his explanation that he merely moved the firearm because he didn't want to be caught with it because he didn't want to get shot really doesn't make any sense. If he truly didn't want to
Why
be,
do you think that doesn't make sense?
well, if he truly didn't want to be seen with the firearm, why did he touch it at all? Moving it to the truck requires more touching, not less. If he had not removed it, he could have just left it in the center console, taken the items of value he wanted, moved on to the next vehicle.
You
But instead,
don't disagree that as a principle, general principle, if you're choosing to commit activities that you shouldn't be involved with, not having a gun on, if you're being confronted by the police, could result in you being safer than if you had a gun on you.
absolutely, you're less likely to be shot and killed by the police if you're not armed while engaged in crime. Yes, Your Honor, absolutely agree with that.
Okay,
But
but I get your distinction.
to follow his logic, though, he picked it up and then moved it away from the center of council, out of the vehicle, all the way to the end of the F-350 pickup truck. That entire time he was walking from end to end holding a firearm where he could have just not touched it at all. So I have nothing further unless the court has questions.
None?
Judge Murray? All right, thank you. All right,
Thank you, Your
thank you, counsel. What branch of the service were you in?
Army.
Okay, good. Our daughter's, my wife's, my daughter, middle child is Army captain right now, so.
Hopefully she sees 04 soon. Major?
Yes, I agree. Yeah. No, I have, 04. I remember the pay grade, so. I did 28 years, and so, anyway, are you still in the reserves of the Guard?
I'm in the reserve.
JAG?
Yes, that's right.
Do you know Captain Hilger?
I'm sorry?
Do you know Captain Hilger at JFHQ?
Yes, she is in the Army National Guard, and I had a case with her once. Yes.
She is. Yeah, that's our daughter.
Oh, wonderful.
Okay.
Small world.
Okay.
Thank you.
Well, thanks for your service. Yep. Go Army, as difficult as that is for me to say as a 28-year Navy guy. So anyway, Ms. Walsh. All right, great. Thank you both. The matter submitted.
Seeing you.
Okay.
You know what? Could I trouble you for?
Okay, yep, we're going to take, you want 10 minutes?
Sure.
Okay, we're going to take a 10-minute recess. We'll begin again with the Bronson case, number 7, followed by number 9, the Ashen case, followed by number 10, the Neveu case. And those are the 3 cases we have remaining today. So court's in recess until 11:30. Thank you. Out of my pocket, or I'm gonna have to go to the ER. So, okay. All right. We continue with panel 5 of the Michigan Court of Appeals, May 5th docket. This is the last case on our 10 o'clock portion of the docket. It's Bronson Healthcare versus Progressive Michigan Insurance. It's the appeal of a summary disposition that was granted in favor of Progressive Michigan. We've read the pleadings. Look forward to the arguments.
Good morning, Your Honor. Ryan Duffy on behalf of Bronson Healthcare Group.
Is there much to say in light of Mary Free Bed?
No, it's a great point, Your Honor. I would say I get to say something I don't normally say, and that's I agree with opposing counsel that Mary Free Bed controls. I was there on the day of the argument. Our firm argued the Mary Free Bed, and then I argued the exact same case 15, 20 minutes later. So the facts are completely on point. There's really nothing to distinguish here. And so unless the court has questions for me, I will stand on our brief.
Yeah, I don't, but Judge Murray, do you have 20 or 30 minutes worth of questions for us? Okay, it's not so indicating. All right.
Thank you.
I think you have time for rebuttal if you choose to. Okay, counsel.
Good morning, Your Honors. Neil Hansen here on behalf of Progressive. I have no intention of wasting the court's time. However, in the interest of
thank you for your briefs.
In the interest of doing my job, I will say I obviously disagree with giving all deference in respect to the court. I did disagree with the Mary Free Bed decision.
So you want us to convene a conflict panel?
I'm putting on the record that would be my request, and I'm not going to waste.
Authority to once application's been filed?
I think I would defer to Judge Murray, but my
Yeah.
thought is.
Former
we still
chief?
Can.
Yeah. Can we?
Convene.
I don't think I don't know if it's after it's been granted or once it's been filed. I don't remember.
My memory was because we did have a whole lot of cases during COVID where various panels were saying various things and they weren't necessarily all in complete and total agreement. And the questions we did address and talk about internally, or at least I called the people who would know and say, hey, can we even convene a panel at this, blah, blah, blah. Anyway, so.
I think Judge Murray's getting out the court rules.
Oh, gosh.
I am. That's the benefit of being in my office.
Teacher's pet.
Well, In the interest of brevity,
Yeah.
I'm going to be very brief anyway.
Okay, please.
I'm not going to rehash any of the arguments that are in my brief that are obviously or were obviously raised by USAA in their own brief, other than to say clearly I agree with USAA's positions.
Right.
There are 2 points I did want to make, though, because I think they're points I had originally briefed in my appellate brief, which was clearly filed long before USAA was decided. That didn't appear to be addressed. I won't pretend I was here for the oral argument, but I didn't see them addressed at all in the opinion and order in the USAA case. And they do seem to go to some of the rationale as to why that court ruled the way they did in USAA. The first one is essentially the idea that the No Fault Act is completely silent on this idea of priority stacking. And I would certainly agree that in 3114, it is. You're not going to get any disagreement from me in that regard. But one thing I didn't see that was addressed in the USAA Mary Free Bed case was application of 3135. And there is a statute in the tort provision of the No Fault Act that specifically verbatim says if you have remaining damages after you present your PIP claims under a capped policy or a policy issued under 3107D with an opt-out, that's your recourse. You're supposed to claim them as part of the negligence action. It's right in there in 3135(3) subsection C. So I would argue that the No Fault Act as a whole is not silent on where those remaining damages would come.
Under the statutory interpretation principle of expressio unis exclusio altero, meaning when the legislature says specifically speaks of one thing and doesn't in another, they've said where it's to be a tort remedy aspect of the litigation. They've told us that, but they didn't say that as relates to the potential stacking of priority as relates to this unique claim under motorcycles. Why isn't the position that you take lead us to the exact opposite result?
I would argue based on the plain language of 3135(3)C, I don't see how that can be read in any other way aside from saying that if you have excess PIP allowable expenses after any capped policy is paying out on those claims, whether it's a motorcyclist or a motor vehicle or a pedestrian, whoever it may be. I mean, the statute verbatim, tort liability is abolished except as to damages for allowable expenses as defined in section 3107. That's the no fault section for allowable expenses, including all future allowable expenses and work loss in excess of any applicable limit under section 3107C. That's what this is. This is a claim for those allowable expenses in excess of the applicable limit at the top of the priority chain. So my position is simply, and I certainly respect differing opinions, that there would be no reason for the legislature to have put that in the tort section if their intention was to allow any claimant, motorcyclist or otherwise, to just move down the priority chain when there's a cap policy paying at the top.
It's such an unusual set of circumstances where you have, you know, the decedent, in this case, plaintiff, or not, he's not the plaintiff, it was the patient for whom the plaintiff seeks the reimbursement of the treatment that they provided. But it does seem in the motorcycle world, it's a little different because he does it. And I know under his Geico policy, he has no PIP, which is what covers the motorcycle, but he has in this other policy, unlimited lifetime benefits, which many of us have selected. And he's injured in a motor vehicle accident, and it just, because it was a motorcycle, he never gets to have the benefit of that.
It's a fair point. I wouldn't disagree with it. And my response to that would probably be to go to the second point in my brief that I don't think was addressed in USAA, which gets to the cost and the rationale. And the USAA, Mary's.
Do you know, and I don't know the answer to this, do you know if in the progressive policy that Bronson's patient had that provided unlimited PIP, is there a provision anywhere where he or whoever the insureds were would have had to say, oh, and yeah, by the way, I have a motorcycle and I ride it?
It's a great question. I do not believe it is in this particular policy, which is exactly what I was about to get into, because I have a sneaking suspicion that's what
It
we're
will
going to
be
start
soon.
seeing.
Yeah.
And, you know, I bring this up because the other main driver or rationale, it seems, behind Mary Free Bed and USAA was, you know, talking about what the point of the 2019 amendments were and, you know, promoting consumer choice, which I fully understand, but
And making it easier for consumers, which I have yet to.
Oh,
think.
I think we're all in
With the
agreement on
council.
that.
Mission not
We could
accomplished.
all have a
Nope.
long discussion on
I
that.
have a lot more briefs filed in front of your honors
I
now
might-
than I ever did before 2019.
My comments, if we were off the record, might not be entirely judicious. So, yeah.
That being said, the other primary focus on the 2019 amendments was obviously cost cutting, saving money. And our position is that, frankly, the end result of Mary Free Bed is going to clearly have the opposite effect, as Your Honor was noting. In the past, obviously, there was no ability to buy capped coverage. There's no ability to buy these opt-out policies. The only way a claim came to a person like Nicholas DeAnda's own motor vehicle policy was if it just so happened you got hit by somebody who was driving around uninsured.
Exactly.
And it was,
that's I mean, that is the very difficult part to process for me on the ramifications of that and the fact that you can have unlimited PIP, but if you're the at-fault driver and person who is injured has, you know, the lowest level coverage, now that's a tort claim.
and that
I don't know about anybody else, but it's my family and I have a substantial umbrella policy now as a result.
that is the way I believe the statute should treat it in light of what I just argued.
Yeah.
But with that being said, to your earlier question and point, the costs will go up because in the past, we only had to deal with those claims when you just unfortunately got hit by someone with no insurance. And that wasn't incredibly uncommon, but it's certainly far less common than now, where you have exponentially more and more people buying capped or opt-out policies.
Right.
Now, every time something like this happens, and we were talking before we got up here, we've got 3 of these cases between the 2 of us, it's going to result in this sort of domino effect. And now you're going to have people who, or insurance carriers, when any insured goes to apply for insurance that says, do you have a motorcycle? Premiums are going to have to skyrocket.
Oh my gosh.
That's
yeah.
the only way to cover this. And that does run, you know, you go back and read the Mary Free Bed opinion, and the whole point is, what was the goal of 2019 reform? Well, if it was to drive down costs, I don't think that decision is the way that's going to get us there personally. To say nothing, of course, of the administrative costs. I mean, this will be the first time ever that we're going to start seeing these claims go to carrier A, who will pay, process, collect everything, and then one day wash their hands and say, we're out. We don't have anything left. And carrier B will be sitting there, who knows how long after the claim was presented, no claim file, no idea what's out there, no idea what's been paid. And they got to start the whole process over. This is going to result in a ton
I
of
don't know
unintended
if
litigation.
Judge Rick or Judge Murray or you 2 counsel have seen it, but in the situation where you have a limited coverage and then it's the FIFO model, who first in from business school when I had accounting, first in, first out. How do we, you know, and then somebody comes in later there's been really wonderful, you know, post-trauma care provided, and the provider says, okay, and they said, well, that's okay, but there's no coverage left. And it's just,
And think about it from another logistical perspective. If you have a claimant, say, with an attendant care claim, and that goes in and eats away at some of the coverage, and then the same claim is presented to a second insurer. And I realize, obviously, insurers can absorb costs certainly more than the average Joe, but how do they know that claim's been paid?
Right.
And they pay it twice. And then what's the recourse? Or if another insurance company paid a bill and the new insurance company gets the file, they have 30 days to decide what to do. How do they know if it's been paid or not? So then you get a double payment,
it's a
then you get a
quagmire.
new lawsuit. Not to go in circles.
I'm glad we have fine lawyers like counsel of record and their firms that are going to help us clear this up and get to the most.
I appreciate you indulging my arguments.
Okay, thank you.
Thank you very much.
Any Want to join the soapbox or are you good?
Not really. All I would say, Your Honor, is I have a hard time having sympathy for any insurance company's administrative costs to process claims, that this somehow would increase their burden based on my experience in this world. But that's all I can.
Okay. That's a little bit off the record, so we'll, but thank you for both of the submissions and arguments. It'll be interesting, frankly, it'll be interesting to see if leave is even granted. So the matter is submitted. Thank you.
Thank you.
The next case is the first case at our 11 o'clock docket. It's now 11:45. Sorry it took us this long to get here. Matter is David Ashen versus Joe Ashen. The appellant is pro per endorsed and the defendant is endorsed as well. All right, Mr. Ashen, you may proceed. Please, if you was presenting discussion with us, make your appearance on the record.
Thank you, Your Honor.
Welcome.
This was a,
Mr. Ashen, you are David Ashen.
yes, ma'am.
All
Yes, Your
right,
Honor.
thank you.
Please proceed.
There was a piece of property. It was part of my old grandparents' resort. And Joseph Ashen filed a quitclaim deed.
45 years ago, plus.
Yes, sir.
Okay. Why is this not a frivolous case and why are you not a vexatious litigator?
Okay.
Such that you should be saying.
First of all, I did a title search and the property was, the reason the property was switched over to my brother was because of a quitclaim deed by my
Let's
parents.
assume all of that's correct. Okay, let's
sir.
just assume it is. And that happened 2.5 decades ago,
Okay.
correct? How do you have the ability to bring the defendants back into court 2.5 decades later?
I think fraud, for one thing.
Statute of limitations on fraud is how many years?
Well, I believe that judicial misconduct, fraud on the court has no statute of limitations.
Under what statute and or case stands for that proposition, sir? Because I am aware of none.
All my research stated that.
What is the statute and or case law which so states under Michigan jurisprudence? What Michigan law supports that position?
Your Honor, that's on the record. I don't have that in front of me right at the moment.
Okay.
So as it turned out, the jurisdiction wasn't even correct because it was in my grandmother's name. The title search proved that. And there was 3 recommendations in a process on this quiet title action. And I think the appropriate thing to bring up at this point is the statement on the title of the case was default judgment for quiet title. And from what I understand, default means that people didn't show up. And a lot of the kin folks didn't show up. They were defaulted. But my sister and myself stayed right to the end. So we had a case where it was a motion of summary disposition during the case where my sister and I won. And then in the same paragraph, we lost. And there was no signature. There was no date of the incident for that hearing. My brother's
What was this?
pardon?
What year?
1999.
Okay. All right. And go ahead.
My brother's attorney stated that the probate was taken care of to the court as part of the situation. And then he said it would be probated again. But in 1988, the probate court records proved
Mr.
that.
Ashen,
This is Judge.
I had a question for you, sir. With respect to Mr. Buell, are you suing him for decisions he made in the quiet title action?
Yes, Your Honor.
Okay, and then how do you get around judicial immunity where our statutes say that you can't sue, and I think the common law as well says you cannot sue a judge for decisions he makes in the course of a case.
Your Honor, I believe that the evidence shows it was fraud on the court. There was like a conspiracy. That probate was never.
And again, going to what Judge Redford said, what case says there's an exception for that? It's absolute judicial immunity. So where is the exception to absolute immunity?
I understand that if you're out of your jurisdiction, or if you're operating without the court jurisdiction or proceedings correctly, then you can be liable for a situation.
But you didn't argue jurisdiction, you just argued fraud. There's a
Well,
difference between fraud and jurisdiction.
It's not the jurisdiction, because this whole situation came apart. According to my brother's attorney, they claimed it was probated in 1988, but proof in the pudding, it was never probated. So it was still in my grandmother's name. So the jurisdiction to give the property to my brother on a quiet title action, it seems like a moot point because my parents never owned the property.
All right, well,
But
that doesn't answer the question, but I would suggest you proceed cautiously.
Thank you, Your Honor. Now, 3 affidavits by my brother stated he bought the property in 76. He stated he got it on, by living there for 15 years, adverse possession. And then he also stated that he got it on quick claim title. None of those are in the Register of Deeds.
I want to give you the chance to address something on the record.
Yes, Your Honor.
It's a court rule, MCR 2.16 sub C. And I'm going to read it to you in its entirety. It's about 4 or 5 paragraphs, about half a page in fairly small type. It talks about vexatious proceedings and a vexatious litigator. It says the Court of Appeals may, on its own initiative or, excuse me, on the motion of any party filed under MCR 211C8, assess actual and punitive damages or take other disciplinary action when it determines that an appeal or any other of the proceedings in an appeal was vexatious because. And I want the Supreme Court to understand, in 8 years on this bench, I have never addressed a litigant with this particular court rule. And in the time that I was a circuit judge for 12 years and 10,000 cases, I probably addressed it only 3 times. Continuing on to the court, and I say that to emphasize the rarity that I have ever seen this used, but it is being presented to this litigant. So he has the opportunity in open court to explain why he shouldn't be found to be a vexatious litigator, at least in answer to my question. Sub A, the appeal was taken for purposes of hindrance or delay or without any reasonable basis for belief that there was a meritorious issue to be determined on appeal, or B, a pleading, motion, argument, brief, document, record filed in the case, or any testimony presented in the case was grossly lacking in the requirements of propriety, violated court rules, or grossly disregarded the requirements of a fair presentation of the issues to the court. Subparagraph 2, damages. Damages may not exceed actual damages and expenses incurred by the opposing party because of the vexatious appeal or proceeding, including reasonable attorney's fees, punitive damages, and an added amount not exceeding the actual damages. The court may remand the case to the trial court or tribunal for a determination of actual damages. Subparagraph 3, vexatious litigator. If a party habitually, persistently, and without reasonable cause engages in vexatious conduct under Rule C1, the court may, and the court, that's referring to the Court of Appeals, may, on its own initiative or motion of another party, find the party to be a vexatious litigator and impose filing restrictions on the party. The restrictions may include prohibiting the party from continuing or instituting legal proceedings in the court, meaning the Court of Appeals, without first obtaining leave, prohibiting the filing of actions in the court without the filing fee or security for cost required under MCR 7.209 or MCR 7.219 or other restrictions the court deems just. I have read your pleadings. I have listened to your arguments. I do not speak for my colleagues, but I can speak for myself. I do not comprehend how the defendant, retired Judge Buell, is not entitled to absolute immunity. And I don't understand how I still don't, I haven't seen any authority to suggest he isn't. Additionally, that which is complained of is from 25 years ago, and it's been the subject of other appeals. I'm having trouble understanding why this panel should not conclude that you are a vexatious litigator and that restrictions or conditions on your ability to file appeals in this court should not be imposed. And I would like to give you the chance during the 30 minutes, and of the 30 minutes you have, there are now remaining about 20 minutes. You can use some, all, or none of that time to explain, to answer that question. If you want to, you don't have to. You absolutely don't have to. But I can tell you as a judicial officer, it is a question that is forefront of my mind.
May I, before you answer, may I also just acknowledge that I was on 2 panels where you previously had cases, one of which was against the city of South Haven from March of 2025, docket number 369827. And the other, the month prior, was heard involving Judge DiStefano, docket number 369042. And that was decided in February of 2025. And both of those you lost, finding there was no merit. So I join Judge Redford's concern and want to underscore for you how important it is that you answer his question about whether you are vexatious
Yes,
or
Your Honor.
not.
Thank
you.
I discovered this situation that the property was in my grandmother's name by doing a title search. Within that time period, that's when I brought these proceedings because I had no idea it wasn't part of my parents' property.
Right. Okay. Assuming what you just said is the absolute truth, anyone will be sympathetic to that. However, what you're arguing is that through another person's conduct while a sitting serving judicial officer, that is what you are seeking. I think tort damages. You're seeking damages that you suffered, right?
Yes, Your Honor.
Okay. Michigan law, as Judge Murray pointed out, provides absolute immunity to judicial officers for their judicial decisions, whether they are right or they are wrong. I don't know if you were here earlier. I was reversed on a very substantial criminal procedure case years ago that still, we talked about it a lot today. The individual whose case that I was the judge on, that it was reversed under Michigan law, his remedy is appealing his conviction. He can't bring a tort action against me for a decision I made as a trial judge. And that appears to be precisely what you're seeking to do in this case. And I don't understand why you continue to think that that's permissible.
Your Honor, I'm not the greatest at the law, but if the case went back and was retried and brought back without a tort situation just to bring justice out, I would be happy with that.
Right. But sir, okay. All right. I understand.
And the motion for reconsideration, on Judge Buell's situation, the lower court judge stated that maybe we should have had discovery and maybe we should have let the case go a little further, I guess to bring the facts out.
Right. No, and again, I mean, trial judges get reversed. That's why we have a court of appeals. I mean, all three of us, all three of the judges on your panel were circuit judges before. We had to call the balls and strikes fast as the ball was coming down over the plate. And everyone, I know that Judge Rick and Judge Murray, extremely bright, extremely conscientious. I gave my level-headed best as well. But if you decide enough cases, you're going to make mistakes. But that doesn't mean that you have the ability, after all of the appeal periods have passed and after the statute of limitations have passed, you can't then get reconsideration. And the sort of fail-safe remedy that you look to is it's not you get to sue the judge because they were wrong. That's not what the law is in the common law or under our Michigan law. I understand personal family properties are intensely emotional and intensely invested and very hard to let go of wrongs that may have happened decades ago. But sometimes that's what happens. What else do you want to say as far as the vexatious litigation question? Because it's a serious issue for me.
Not trying to be vexatious. I never brought any case to be vexatious. If there was a situation where it was outside the jurisdiction of the court, then I understand that there could be a remedy.
Okay.
And that's basically what I'm relying on.
All right. Anything else you'd like to share with us beyond your pleading? Because we have had a chance to read those.
No, Your Honor.
Okay. Thank you, Mr. Ashen.
Thank you, Your Honor.
You're welcome. Mr. Buell. We've read your pleadings. You've heard my questions and comments and discussions and dialogue with the plaintiff as well as my colleagues. Happy to listen to anything you have to say.
I'm just here to answer any questions you may have. I think my brief covers everything. I'm impressed. Sometimes courts say, well, I've read your brief, I prepared. Obviously, this court is more than prepared, and I'm quite impressed with that. I would only say in my 58 years of practice, I filed a lot of briefs in this court, but they were all 50 years ago.
I know that feeling.
But I never.
Mine are 35 years ago now.
I never appeared for oral argument. So this is my first.
Oh my gosh.
And Mr. Ashen has far more experience in oral argument than I do.
Mr. Ashen presents very well.
I appreciate the seriousness with which the court has addressed this issue. I'm currently defending another case that Mr. Ashen has brought that I hope never comes here. And I hope he's listening. And that's all I have. I
do have
appreciate
one question for you.
Yes.
Counsel. Is it a correct understanding of the record that you did not bring a motion under 7216C1 in the trial court?
I think that is
the vexatious litigation.
No, I did not.
Okay.
I did not. I brought an action for criminal contempt under that statute, section 7, I think it was. It deals with deceit or abuse of the judicial process. And we had a hearing. It was a criminal contempt, which I had difficulty convincing my trial judge it was criminal. And he was found not guilty.
Okay.
And so that's why I made my prayer for treatment here as a vexatious litigant, because I did my turn in the barrel there
Right.
and was unsuccessful and that was my reason for that.
Okay. All right, Judge Rick,
I have no questions.
Judge Murray?
Thank you.
all right, thank you.
Thank
Appreciate
you.
it. Mr. Ashton, anything else you'd like to share with us? All right, thank you, Mr. Ashton, for being with us today. I come from a large family, and families are the greatest blessing and sometimes the source of the greatest frustration. And sometimes things happen decades ago that you just can't let go. And it's really hard, really hard. So I hope you're able to find closure that's satisfactory to you at some point, Mr. Ashton. So you're welcome. All right, this matter is submitted. Next case is In Re Neveu Minor. This is our 10th case of our case call today, case 376713. I believe we have a student litigator that we have the privilege of spending some time with today. Is that correct? All right. If you could give the panel just a moment, I want to put my number 9 folder off to the side.
I understand that Professor Sankaran is touring the country, teaching judges how to be more compassionate. So counsel, student counsel, who did you bring with you since it is not Professor Sankaran?
This is Professor K. He was my supervisor on this case, but just a note about Professor Sankaran. He teaches a class with Professor Carr.
Yes.
Called Designing a Fulfilling Life in Law. And I took that class. So I spent more time with him in that class than I ever did in clinic. And he tells us all about his judges retreats. He just had one this weekend. And yeah.
Does he name names?
No.
Good.
But I highly recommend you taking like one of those retreats because he's so passionate about his work and it means a lot to him. You did? How did you enjoy it?
Yes, with he and Professor Carr, and it was amazing.
Oh, I love that.
Okay. And we also have Russell Lewis appearing remotely to answer our questions. Mr. Lewis, thanks for being with us. I'm sorry it's taken us so long to get to this part of our docket, but we've had some well, you've been in the room, you've seen what's going on. So, all right, at this point then we'll have our young student, if you could state your name, please.
Catherine Perez,
Okay.
Oviedo.
Now, where are you from?
I'm from Cincinnati, Ohio.
All right. But you're going to Michigan.
Soon not to be. I graduate next Monday.
Oh, congratulations.
Thank you.
What bar are you going to take?
New York.
Holy cow. Okay.
Yeah.
Man, you're all over the map. Well, good luck. That's
Thank
great. Do you have a
you.
position lined up?
Yes. I will be working for a law firm in New York City.
Very nice. Good luck.
Thank
That's
you.
a wonderful achievement. And where'd you go to undergrad?
I went to Ohio State. I refused.
What do you wear at the big game?
I wore Ohio State when they play directly against each other, but I
Okay.
wear Michigan for the other games. So.
You know what they do to the Block M.
Yes,
at
I
Ohio
know.
State. I had no idea till I toured the
It's
campus.
outrageous. I went to college in Ohio, not the Ohio State University. but,
Which school?
John Carroll.
Oh, yeah.
little Jesuit school up in
In Cleveland,
Yeah,
right? Yeah.
exactly.
That's where Marcelo Hernandez went. If you know who that is, the SNL.
Yes. Okay. Wow.
Yeah.
All right.
He's
So did Tim
the hot
Russert, but you
guy
don't know
on there.
who he is, but, and so did Don Shula, and you
Oh,
also
wow.
don't know who he is probably, but yeah, one of the great coaches. All right, we've gone down a frolic and detour of my making. Now Murray is going to chastise me roundly, both tomorrow in person and as soon as we begin caucus electronically. So I apologize, Chief.
Yeah, she's Professor Saccharin would say, I'm one of the judges that needs to go to his retreats.
She's going to record it.
Tell him
Hey,
you said that,
send an
yeah.
invitation to this guy. He needs it.
Yeah.
Okay, counsel, please proceed.
Alrighty. Good morning, Your Honors. May it please the court. My name is Catherine Perez Oviedo, and I am a student attorney with with the Child Welfare Appellate Clinic at Michigan Law School. And I appreciate the opportunity to argue before you today on behalf of the respondent appellant, Mr. Slike. The juvenile court erroneously terminated Mr. Slike's parental rights for 3 reasons I set forth in our brief. I will focus my argument today on two of those issues. The first one being Mr. Slike's inadequate no contest plea, and the second being the juvenile court's failure to explicitly consider the child's placement with relatives and its failure to weigh this fact against termination. So the first issue, the plea issue, Mr. Slike was misled and did not make his plea knowingly. We know from In re Ferranti that the Michigan Supreme Court affirmed the right for a respondent to challenge a defective plea following termination, and pleas must be knowingly, understandingly, and voluntarily made.
I mean, he's facing felony charges, right?
He was at the time.
At the time. Those have now, I assume, been resolved. All right, so he's facing felony charges related to the exact same conduct, which is the underlying basis of the petition, right?
Correct.
And he's represented by separate counsel in that case.
Correct.
In what scenario is he ever going to do anything other than waive?
That's a great point, Your Honor. I think So one of the main reasons that I argue that it was not knowingly and understandingly made, regardless of if he would have made that same choice had it been, was that the allegations that he was pleading to were never read aloud before to Mr. Slike before the court had accepted the plea. And so
I have on that point, I have a note here, and correct me if the note's wrong, but on May 12th, 2023, the referee read the petition to respondent.
On which date? I'm sorry.
May 12th of 2023. Is that not accurate?
Was that the hearing that he pled no contest to?
No,
I think it was before that.
So he pled no contest on September 11th, 2023, I think.
Yeah, so it was a few months before that.
Okay. Yeah, so I think if that's true, then I think what is important is that when the court is accepting the plea, that the allegations perhaps are read aloud again. At least that's what was focused in Ree Peterson and the couple other cases that I've read to support this claim, is that when the plea is made at the time the plea is made, that it is knowingly and understandingly and voluntarily made.
So you think it would make a difference though, if like in this case, the information was read to him out in open court, just not at the exact same time he pled no contest? I mean, he's being, like, as Judge Redford suggested, he's being criminally charged for it. And then he has a petition read in this case to him. And then, what was it? 4 months later, he pleads no contest.
Yeah, I argue that it would make a difference because it also not just focusing on the allegations. There was a quote that the court had stated when that also indicates that it was not knowingly made. So when the court was accepting his plea before it, the court stated, and I quote, "There would be nothing that you're admitting that would be used against you in an ultimate termination request." And this ended up being completely contradicted when the court had rendered its factual findings when finding statutory grounds for termination. It did consider the entire file, including.
But the court also said that he would. So I think your best argument is saying ambiguous, maybe, but because the court did also say that by pleading no contest, that the allegations will be accepted as true.
Exactly. I believe that was all in the same paragraph. So yeah, very ambiguous. I would agree, Your Honor, and also very confusing having that been in the same paragraph saying there's nothing that you're admitting to that could be used against you, but also we can consider the entire file and we'll be accepting it as true. I think that was confuser to me as the student attorney working on this case, I'm trying to understand. So I can only imagine how confusing it would have been for Mr. Slike accepting the no contest plea at that time.
I thought an argument might be made that the trial court judge, in making the comment about use of the no contest plea, was comparing it to the criminal action versus the instant action, because obviously the standard of review or the burden of proof, the burden of proof is differently. It's a higher threshold in a criminal matter. So a no contest plea in a termination proceeding on jurisdiction, you can't just take that to the criminal court and say he admitted it or he didn't.
Right.
Yeah. So I thought that it was rather ambiguous because I couldn't pin it to a point of reference, that it made it all the more confusing.
Are you referring to at the hearing at the plea hearing or the termination hearing?
I'm talking about the plea hearing.
Yes,
I saw, I read that several times, and how I interpreted it was that while the judge was trying to be colloquial with the litigant, that his point of reference wasn't communicated, and that could be very confusing and perhaps create problems in terms of voluntary and yes.
Thank you, Your Honor. Yeah, the judge said like the petition's allegations, and I'm not sure if it was ever clear which exactly petition they were referring to.
Not to mention your client also reiterated that he was of the impression that they were still moving toward reunification.
Right, so exactly. So it became clear through Mr. Sykes' responses at that hearing that he understood that the next step would be towards reunification, and not fully understanding the consequences of the plea, specifically that it was going to be later used against him at the termination hearing.
And may I ask, because there was another issue I think you raised with regard to the plea in terms of being properly advised of appellate rights. And the fact that you're standing here today, he did get them, even if he did not. So what's your response to that? Because I think it's like, well, yeah, the judge missed it in recitation, but here you are. So you did get them.
My response to that is just that MCR 3.971 says that a court shall not accept a plea without satisfying, I think it's like 1 through 7. And the right to appeal was B6, and they just simply didn't. The juvenile court did not read that aloud, but as you just said, it was not determinative as I am standing before you today.
Thank you.
Moving on to the relative placement argument, the law in this issue is clear that failure to explicitly consider relative placement and weigh this against
the child was placed with a relative in Wisconsin, I think, right?
Correct. But the court did not explicitly consider this one in its best interest determination. We have In re Mason, which is a Michigan Supreme Court case, which laid out this rule. In re Olive Metz was 2012, where this court affirmed the rule. I'm sorry.
Olive Metz is the one it's often cited to us.
And then actually, as recent as this year, earlier in 2026, this court again, in re Gentry, reaffirmed the principles set out in Olive Metz and Mason. Therefore, clearly showing a reaffirmation that this principle and rule set out in the court must be included, and that the failure to do so warrants reversal. And in this case, the juvenile court never explicitly considered the child's relative placement in Wisconsin, and never on the record at the termination hearing, when rendering its best interest determination, considered what that might mean and how that weighs against termination.
And that was what my question was going to be. It's not so much whether it was read or not, but that despite the fact that there was a relative placement that the court nonetheless elected to terminate the rights. Is that the thrust of your argument? Am I getting the thrust of your argument?
I'm sorry, can you repeat it?
Sure. So in your, regardless of what the judge may have said or commented upon in terms of relative placement, isn't your argument that because the child was placed with a relative, that termination was unnecessary? Or is it in the is it in the recitation, the bases of its?
I'm not so much arguing that. I think that would be a question for the trial court. I'm more so arguing the law and just simply the fact that the juvenile court's failure to consider it warrants reversal because that's what the case law says, not that
Why do you
because
think the court failed to consider it? I mean, the court had to be aware where this child was.
I think it definitely
authorized
was.
it,
Yes,
didn't he?
it definitely, it was clear through the transcript that it was aware of it, but in its discussion, towards like the end when it was making its best interest determination, that's when it should have dove deeper and explicitly considered it, and its failure to do so is what warrants reversal. And then whether or not termination of Mr. Sykes' parental rights is necessary or in the child's best interest would be a consideration for the trial court after it weighs this fact.
Well, we have a 17-year-old, I'm sorry.
Yes, she'll be 17 in
17-year-old.
September.
And
Yeah.
she's indicated her preference, and this is the child's best interest,
Mhm.
right? So.
Yeah,
You're in.
I think, again, I think that's a question for the trial court. I'm sorry to keep like repeating myself. Mr. Syke wants a relationship with his child. It is clear
It was
that,
said she does not want
Yeah,
one with
it is
him. And it's
clear.
not like this is a 5-year-old.
Right.
When she's making those statements, she's over 15, I think, right?
yeah,
Having raised 3 children, 15-year-olds speak, it's like the old E.F. Hutton ads, people listen, so you have this teenager, now nearly adult. And just, so is your client still under the supervision of any criminal jurisdiction that has probationary limitations on him?
we believe so. We would have to double check.
Well, it's important because one of the conditions of probation was that he not have any contact with the victim, right?
Mhm.
So he says, I want to have a relationship. This is so important to me. Yet both the family court said you'll comply with the orders of the criminal case for your criminal activity, which I think he's been convicted of, correct?
Correct.
All right. So he's been convicted of crimes against his daughter. And part of the terms of probation are you can't have any contact
Mhm.
with this child. She's 17 years old. To what end is when the defendant in the criminal case and the petitioner or the parent in this particular case has been advised in May of the year that the separation takes place or that the court takes jurisdiction while he's pending criminal cases. And he waves and says, I want to move forward with whatever I need to do to get to reunification. Says that on the record. Is it appropriate for this court to reverse the decision of the trial court to terminate parental rights? Given where we're at in this stage, at this proceeding, and taking into consideration what the trial court did do.
Yes, I do believe, I do believe it is appropriate for this court because there are, the jurisprudence here in Michigan has made the procedural protections afforded to parents very clear. And I understand your concerns given the child's age and the possibility or maybe impossibility of a reconciliation of that relationship. However, Mr. Sykes' parental rights and procedural protections in this case were violated, and he at least deserves a fair chance at, trying again.
Thank you.
Thank you.
Judge Murray, any?
Sorry.
No, thank you.
Thank you.
Thank you, counsel. Professor, thanks for being here. Mr. Lewis, any of the members of the panel have any questions for Mr. Lewis?
No.
Mr. Lewis, I'm going to also be chastised later by Judge Murray I'm going to ask you a question.
Thank you.
In all seriousness, I mean, was the father, was the May reading of the information, does that in any way cure the defects which might be apparent from the record?
Well, yes, I believe it. First of all, I don't think there's a defect. He was read the entire petition. I'm in front of this judge very often. I've never seen a more due process oriented judge, or he's right at the top of my list. And the petition was fully read when he first appeared in court. When he decided to enter the plea, something the other counsel is forgetting to mention is he was fully represented. He had an attorney present. The attorney was asked, do you want to speak to your client? And he asked the client, do you want to speak to your attorney? He said, no, I want to do this. So I don't think there's a defect. I don't think there is any due process defect here whatsoever. And again, being very familiar with this court and appearing in front of it, monthly or more, I know what the judge would have said or did say in all of these hearings. So he was fully advised.
What about, can you please address the issue that I'm pretty fixated on, which is the impact of the no contest plea? I mean, that is clearly, if.
Oh, yes, Your Honor. I'll be glad to reference that. And I referenced in my brief, which I just stand on my brief. I don't need to say any more, I realize, but he didn't do anything else. They called
who is
Mr. Sleek. Mr. Sleek. I'll refer to him as respondent because I don't want to use my client's name, but the minor's name. But the respondent had certain things he had to do. He was court ordered in every one of them. He did chapters 1 through 7 of a 47 chapter book on parenting time. And that is all he ever completed. He didn't complete his counseling. Even his own counselor put on the record how he was somehow recalcitrant and wouldn't come to personal counseling, canceled lots of sessions. He didn't, our judge uses the term to follow the plan. And you put a plan in place.
I don't know, Mr. Lewis, but it sounds, the question is, was he advised of what the potential consequences of his no contest plea would be? That I think is the salient question.
Yes, absolutely, Your Honor. I misunderstood the question. I apologize.
But the judge said it won't be used against you. And that was a factor used against him at the time of termination. The effect of the no contest plea, but for him pleading no contest, there could be a trial.
Your Honor, I would respectfully beg to differ. It was not used against him. It was only a way for the court to gain jurisdiction. If he would not have entered a plea, we would have had a trial, either a judge or a jury trial, which you're well familiar with. A 6-member jury would have decided, or the judge would have decided one way or the other. I think under the facts in this case, I've had a few trials recently that were much easier than this one factually, and they always decide almost always decide to go ahead with adjudication. And that's what the plea was to. He wasn't pleading to, any particular facts other than that we could get jurisdiction. And that's when the plan came into place. And that's when he didn't follow the plan. And that's when he didn't show up to court hearings, even though he was ordered to do so, and so on and so forth.
Thank you for that, Mr. Lewis. And thank you for being here on behalf of your client, who is the actual child. You are not with the prosecutor's office, correct?
No. I am the prosecutor. I take it personally. I'm sorry, I am a representative of the Michigan Department of Health and Human Services.
Okay, thank you.
You're welcome.
I got,
Sometimes we have GAL.
Yes.
You know, so it's, yeah.
Well, my GAL, Your Honor, was totally behind this, and at the hearing, you've read the transcripts. I don't need to tell you all this. I'm sorry.
thank you.
No,
Thank you, Mr.
thank you. And we
Yes.
appreciate.
Can I make a comment, and not about the case? Can I make a comment about this whole process today? Do you have 2 seconds?
I enter the portal with caution, but please proceed.
I've been on since 10 o'clock, Your Honors. I taught law for 21 years, criminal law. I have been an attorney for 45 years, or 42 years, pardon me. I clerked for Judge Benjamin F. Gibson as a student law
one
clerk.
of my favorites. One of my
Yeah,
favorites.
mine too, Your Honor, mine too. And I want to tell you that this is the greatest learning experience anybody could ever have. Sitting here, just listening to the arguments and so on. And I really appreciate the fact that you let me zoom in from the Upper Peninsula of Michigan and not make that long trek to my old hometown of Kent County. I practiced law there for a good many years. I think Judge Redford signed one of my orders once, but I never appeared in front of you, Your Honor.
Easiest decision I ever had to make, Mr.
That was an easy one. I think it was a stipulation in order. And but anyway, at any rate, I miss my hometown, but I wanted to let you know I've really enjoyed the experience of sitting here listening. I've learned a lot. I was scared. I've only done this for 42 years, and I was still scared to death to appear in front of the Michigan Court of Appeals because I hadn't done it before. So it's probably my first and maybe my last. I don't know. But thank you for letting me rant a little bit. It's the old professor in me. I just talk too much. So
Thank you, Mr. Lewis. All right, counsel, any rebuttal?
Hello, Your Honors. Yes, just one thing. Because Mr. Lewis said he disagreed at the fact that the allegations within the petition of the no contest plea were simply for gaining jurisdiction and were not used against him. So I would just like to refer to a quote listed in the statement of facts in our brief. It's on page 20, and this reflects what the juvenile court did when rendering its factual findings for statutory grounds. And it said, it is clear on this record. Okay, one more caveat before this. We understand that, he was convicted. And so again, it's not so much of a focus of whether this information could have been gained anyway, but rather what the court did in its error. But it is clear on this record that there was physical abuse regardless of what the jury convicted of, based upon the sum total of the entire file and the allegations within the petition that were acknowledged as being true from a no contest position of the respondent father way back at the time when we took initial jurisdiction. So it was not just merely for taking jurisdiction, it was used against him. And also, just one more note, we know that the juvenile court should not have even considered the entire file until the best interest determination. That's only for the best interest determination, and using the entire file should not have been considered anyway for statutory grounds. And we know that from In re Moss. Thank you.
I have one question.
Oh, sorry.
If a reviewing body were to look at a case, set it aside from this one, and in its review concluded trial court did a lot of things correctly, a lot of procedural and substantive due process rights were accorded, made a couple of mistakes, didn't say these things, but let's hypothetically, if that reviewing individual or a group were convinced that had the person not entered a no contest, or let's say the trial court rejected the no contest, and if there were a hearing, if a reviewing tribunal is completely convinced that there's zero likelihood that the statutory and procedural and court rule requirements for the court to take jurisdiction exist, really without any evidence in opposition, is it still necessary for the reviewing tribunal to reverse?
Can I rephrase the question to see if I'm
Sure,
understanding?
because it's not a very good question. It was word salad, and I apologize. I'm having, it's sort of like, let me just use an example. In our criminal cases, if an accused says, I received ineffective assistance of counsel and I need a new trial as a result. When we look at it, one of the things that the accused has to satisfy the court is that, but for the problem, there's a reasonable probability that it would be a different result. If when we're looking at this and we say, let's say we come to the conclusion, counsel, you're right, didn't do these X, Y, and Z, but we are completely convinced that, okay, let's assume that the trial court had rejected the initial finding,
Mm-hmm.
and you had a contested either jury determination or bench determination. There is a extraordinarily high likelihood that grounds for which to take jurisdiction have been satisfied.
Mm-hmm.
Is that of any moment?
Yeah, I totally understand what you're saying, which I think is like, if we reverse, what's to say this is not going to turn out the.
No, I'm not saying if we
Oh.
reverse. I'm saying we don't think if the mistake hadn't been, let's assume, yes, a mistake was made and we reach that conclusion in
Mhm.
our mental calculus. Mistake was made.
Mhm.
However, we are completely convinced that the record indisputably establishes
Yeah.
that had the mistake not been made and had it gone to a contested hearing on adjudication, there's no question the trial court would have found it. We're not going to reopen this entire thing as a
Mhm.
result. That's the question.
Okay.
Can that be done in Michigan?
Oh. I'm not sure. I do.
Want to meet with your sponsor?
Yeah, sure.
You're still.
Yeah, thank you. I don't have $10 million. I'm challenger for this thing. Yeah.
Okay, ready?
So I'm sorry, I'm fully trying to understand the question. You're saying like does it matter that they would have found grounds to terminate
Yeah,
no matter
if
what?
if a reviewing
I'm
tribunal,
sorry.
in looking at, analogize this to a ineffective assistance of counsel in a criminal
Mhm.
case. One of the things that an accused, in order to get relief, must demonstrate either at the trial court or in the reviewing panel is, but for the below professional standards representation there's a reasonable probability that a different result would happen.
Mhm.
Okay, so my question is there an ancillary principle in domestic relations, child custody, termination of parental rights, where if we're convinced that the trial court made a mistake,
Mhm.
you know, lots of times we find mistakes that the trial court made, but if we find it harmless error,
Mhm. Okay,
we
yeah, I
affirm.
understand.
And that's the question. I mean, or is this, so, yeah.
Thank you. I think this error was not harmless. And that kind of goes into the third issue that I didn't address in my initial argument.
What's rebuttal? So you don't
So
get to
I
address
can't
it
bring
now.
that up. But there would have been a chance for, had these issues been brought in the forefront, perhaps initially, Mr. Syke would have had an opportunity to litigate against those issues, bring forth witnesses, and, you know, had a fair shot to contest those in court and perhaps maybe after court if there was a reversal. So I don't think the error.
That's true in every mistake that happens in trial court. But
So-
routinely, trial courts and appellate courts do not reverse.
But specifically specifically on those points of the plea issue and the relative placement that I gave in my initial argument, no, I think the harmless error lies within the third issue that I did not discuss.
All right.
Thank you.
All right. Thank you, counsel. Thank you, Mr. Lewis. This matter is submitted. All right. The court
Thank you.
then continues. We do not have remaining oral argument. Court will call the case 11 People versus Wild, 365-688. That matter is submitted. People versus Agliata, 37. It's our case number 12, case 375-925. That matter is submitted. And case number 13, In Re Hemke Minor, case 375-662. That matter is submitted. That completes day 1 of panel 5 of the Michigan Court of Appeals, May 2026 case call. And we will reconvene tomorrow morning at 10 o'clock a.m. under the tutelage and leadership of Chief Judge Emeritus Murray in the panel. The court is in recess. Chris.